Yes. So last time we were here, I believe we pointed out so the stop itself and the reason for getting around the car. It's just and not you only do one fix of right. You do all the rest. Okay. So it's just that one there. Thank you. So the question is going to be, there's a reason to suspect that you and the really things that it's like when you go to a bar, and so that's I'm sure he's going to say that it wasn't the report as well as the passenger. He asked, he said, has everybody in the car been drinking? And everybody says yes. Well, except you. He did ask you directly. He said, where are you coming from? And you said, I'm coming from the Loud, which is a bar. And so that's something you can consider that you said you went to the bar. He can also take into consideration that it was like 8:30 in the morning and that it was Saturday morning. You did. Which is kind of neutral. And admission of drinking is obviously something that they could consider. At the same time, you had 2 drinks. He didn't ask when you had those 2 drinks.
I need to be, I'm going to see the dog.
So that's the source of the alcohol. And he got you out. When he got you out, what he put on top of it, he said, notice of abuse. Now, what we all know, that may not mean anything to you, but what we all know is that troopers they physically don't specify the strength. And so usually they'll say strong. And if it's strong, that would not be good for us. Noticeable just means it was, in my opinion, just enough to notice it. The reason that's important is because the more you consume, the stronger it is. Within 30 seconds, you stop at the car and decided who's going to put you in. I think that's the best option. I'm just not going to lay down and say, okay, just plead to this without fighting that. So that's what we'll be doing. Obviously, if you have something to tell me, go ahead. I'll listen to you.
Okay, I'll sit back here.
Yep, that's fine.
Butch.
State of Ohio recalls Kyle Atkins at Lawrence County Jail.
Mr. Warford's appointed as counsel, had to do an assessment.
Yes, we are ready to take him today. The sooner we can get him there, we can get him started on detox meds and get him kind of ready to get started in treatment.
Mr. Warford?
That's what he wants, Judge. I'm going to know this man a little bit. I know his grandmother. I've been close with her for many years, and sort of familiar with the family. And they are all very sad and depressed that he's had a relapse, Judge, and they want to see him succeed in sobriety.
Okay. Let's put him down in 2 weeks is the 5th, I believe. No, that's a Monday, so August 5th works, I think, for the next hearing. August 5th. It's a little more than 2 weeks. So August 5th, order him released to Bethesda. No GPS required. And goes straight there today. As soon as they can get there, take him. And time waiver, preliminary hearing.
Yes, Judge. So
Okay. August 5th for preliminary hearing.
Thank
Order
you.
to Bethesda.
Thank you, Your Honor.
Inpatient.
Thank you.
You're welcome. Good luck. That finishes up at the jail.
And State of Ohio recalls Charles Fricky, case number CRA 24390 and TRC 241281 A and B.
Charles Fricky, come into court. So we got confirmation that the warrant in Georgia is withdrawn. So that just leaves us with the ODI. He is at Lawrence County Recovery.
It's right there.
So we did confirm the warrant from Georgia has been withdrawn, so that makes things less complicated. And how's the state want to proceed?
Looks like Mr. Fricky entered a guilty plea back on July the 1st, is that right?
Yes, sir.
And he's been going to Lawrence, he's finished Lawrence County Recovery.
He's still there. He's
Still
in-house.
there.
He's still there.
So what we would like to do is assist Mr. Fricky in maintaining his sobriety, and we'd like for him to stick with the program. And if he's willing to do that, we would be willing to continue to ask to continue the sentencing so that he can be compliant, and maybe we can make a recommendation at a later date that would be more to his liking if he's successful.
we're agreeable with that, Your Honor.
Okay, let's come back in a month, August 19th. Are you available that day? August 19th will be the sentencing. So the way this works, with your history, under this current statute, there's a pretty rough requirement for sentencing. But from what I understand the state's saying, if you demonstrate that this is going to be long-term recovery and we're convinced of that, then maybe they'll recommend something that's lighter than what the statute even calls for.
I
So,
appreciate that.
I can't do it.
ball's in your court.
Yes, sir.
I can't do it on that day, Judge.
Okay, let's do, let me look, let's see. '23rd?
That'd be a good way to celebrate the day before my birthday, sure.
All right, August 23rd will be sentencing here.
Thank you.
Thank you, Your Honor.
You're welcome. So 24-3-9 is dismissed. That was the warrant from the Georgia case. So now, the only thing we got left is the motion. So we're ready to go forward with that.
And the trooper is in reviewing the video. I'll go with him.
You too. State ready to proceed.
Yes, Your Honor. Call Trooper Barnett.
Please raise your right hand. You swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
You may proceed.
Trooper, state your name and where you are employed.
My name is Charles Barnett. I am employed by the Ohio State Highway Patrol.
Are you working out of the post 44? here in
Yes,
Lawrence County?
Iron, that was 44.
Were you working on March the 16th, 2024 at 1:31 in the morning? And at that time, did you come into contact with Bailey Key?
Yes, sir.
And do you recognize Ms. Key in the courtroom today? And if you do, can you point to her, please?
Yes, sir.
Record will show you pointed to the phone.
At that time of the morning on March 16th of this year, were you on patrol on US 52 westbound here in Fayette Township in Lawrence County, Ohio?
Yes, sir.
And did you see defendant operating a vehicle at that time?
Yes.
Did you, as a result of your observations, initiate a traffic stop?
Yes.
And what caused you to first recognize Ms. Key, and what led to the initial reason for the stop?
I observed the vehicle, drove over the fog line. Then I started to follow the vehicle some more, then drove over the fog line multiple times. And then at one point in time, it was about half a car length she was straddling the fog line. That's when I initiated the traffic stop.
Okay. Now, was your patrol vehicle equipped with a forward-facing camera called a dash cam
Yes.
and a back seat-facing camera within the vehicle? And were you wearing a body cam at that time?
Yes, sir.
Were all those in working order and recording at this time when you made the stop and the encounter with Ms. Key?
Yes.
Did you preserve that video for use in this hearing today?
Yes, it's saved as evidence on Axon.
And have you reviewed that video prior to our hearing to make sure that you know that it's an authentic copy of what happened?
Yes.
What we're watching here, is this a view from your dash cam on this occasion?
Yes, sir.
I'd like to just stop here for a second and ask you, have you already identified Ms. Key at this point in time? Have you already observed something that caused you to start to follow and watch her, or was that not happening?
No, not at that moment.
So were you just driving westbound at that time?
Yes.
Is this Ms. Key's vehicle in front of you?
Yes, sir.
Was that you singing?
Yes.
I do that sometimes. Now, I stopped it here for a particular purpose, and I'd like for you to, this is a still shot of that. I'd like for you to look at this photograph and see if it matches the blown-up version of the picture there.
Yes.
And at that time, it would appear that Ms. Key's vehicle was all the way over the phone line.
Yes. She was straddling at that point.
And this appeared to be a fair, blown up, but accurate
Yes.
representation. I'm going to ask the exhibit one to be admitted.
Any objection?
No objection.
when you initiated the traffic stop? I know it's obvious, but is that?
Yeah, oh, yes, yes.
Now, prior to the point at which I just showed you that picture and we had admitted into evidence, have you seen some erratic driving leading up to that point?
Up to the point to where the vehicle straddled the fault line?
Yes.
Yes.
And what exactly were you observing before that?
Mark lanes, which is not as clear on that video. There was like minor mark lanes, not as well as that one, but it was still over the fault line.
At
The tires were.
that point in time, did what you observed of Ms. Key's driving start to cause you to form reasonable suspicion that
Yes.
there may be impairment?
Yes.
And at this point in time, do you then approach the vehicle?
Yes.
And do you make contact with Ms. Key at that time?
Yes, sir.
Were there passengers in the car with her?
Yes, there was a front passenger and there was a rear passenger.
Did you notice anything at that time which would cause you to believe that she may be impaired?
When I approached the vehicle, I detected like I said in my statement, noticeable odor of alcohol and emitting from the vehicle. And I saw that she had glossy eyes or watery eyes, and I asked her where she's coming from, and she said that she was coming from the lounge. I put lounge in my statement, and a bar in Huntington. I asked her how much she had to drink, and she stated she had 2 drinks.
So all of those things, were those all things that you used to form reasonable suspicion that she may be impaired?
Yes.
The time of day, did that have anything to do with it?
Yes.
Did you ask her to come out of the vehicle then?
Yes, sir.
And when you get her out of the vehicle, do you continue to smell alcohol?
I still continue to detect the odor of alcohol beverage, yes.
Charles 103182, Charles 103182, Kentucky 10. How's it going? I'm doing all right. How are you? Good. The reason why I'm here today is because you drove over the white line here. You're straddling, okay? All right. Where are you coming from?
We went to the Loud.
The Loud? Or Huntington? Okay. How much you had to drink tonight?
I had 2 drinks.
Okay, because I can smell it coming out of the car here. Hey, you mind stepping out of the vehicle for me? You have the driver's license for me? Has anyone been drinking in the car today? Alright, if you want to throw it out for me. You want to walk back to my car here?
We spoke previously, and I think Mr. Nash, it was his objective here to contest just the reason for getting her out of the car. So I think we've presented the evidence that we need to present this time.
That's correct. The issue is just issue 1 in the motion, and that's reasonable suspicion to conduct field sobriety tests.
I do want to ask, if I haven't already, if you continue to smell alcohol after she came out of the car.
Yes.
And did you notice anything, is there anything between when you got her out of the car and when you start the field sobriety test that would further indicate to you that she might be impaired?
I don't recall, 'cause the body cam don't show the video to won't come back too well, and it was a couple months ago. Right
The video that we showed, is it all fair and accurate representation of what occurred?
Yes.
And I'm going to ask that the video be admitted as
To
exhibit 2.
the objection,
No objection.
be admitted.
It's both videos, right?
Yeah, both videos.
No objection.
And that's all I have, Your Honor.
Mr. Nash?
Thank you, Your Honor. Mr. Barnett, good afternoon.
Yeah, so.
Just have some questions closely related to the questions you were just asked, okay? And let me first start by asking you, how long have you been a trooper?
It'll be approximately, October will make 4 years.
Okay,
So,
so almost 4 years. And how many, if you could approximate, OVI investigations have you been involved in?
100 to 200.
Okay, all right. And so to become a trooper, you probably had to study a NHTSA manual regarding standardized field sobriety testing?
Yes.
Okay, and so you're aware of that, is that right?
Yes.
All right. Now, in reference to this manual, you learned that there are phases to an OVI investigation, is that right?
That's correct.
All right, and there's 3 phases, is that right?
Yeah.
Okay, and the first phase would be what?
The first phase is the driving phase.
Okay, and so according to the testimony you just provided, you had some suspicions of OVI based on that initial first phase, is that right?
At the time of the day, at the time of, well, I guess it would be morning, with that specific violation, that's one of the main violations to indicate impairment and impaired drivers.
Okay, all right. And so we saw a video here, which, we saw 2 videos, one of which is your body cam, is that right?
Yes, sir.
Similar to the cam that you're wearing right now?
Yes.
Okay. The other video I think we watched is a dash cam or cruiser cam, is that right?
Yeah.
Okay. Now, when you approach the car and you have face-to-face contact with the driver, are we still in phase 1 of the investigation?
No, it would be in phase 2, that'd be personal contact.
Okay, personal contact. And so the personal contact, you're looking for things that will either dispel or confirm your suspicion of OVI, is that right?
That's correct.
Okay. And can I use that mouse up there?
Yeah,
Okay.
as far as I'm concerned.
All right. Judge?
Yes, sure.
So I think, okay, this is the body cam here. And I think if we minimize that, I'm just looking for, actually, I'll go back to this body cam.
How's it going? I'm doing all right. How are you?
Okay, let me stop that there. And for the record, I've stopped this, and tell me if you agree with me, if you look at the top right, the time appears to be 1:32 with 15 seconds.
Yes.
Is that right? Okay. Now, so this is the face-to-face contact that you have where we've entered phase 2, is that right? Is that a yes?
Oh, yes, sir.
Okay, all right. And I heard you, but I need you to think out loud, just so we can pick up the recording. And so you had detected an odor of alcohol at this point, is that right?
Yes,
Okay, but there's other occupants in the car.
that's correct.
Okay, and in fact, you had asked everybody whether they had been drinking the other 2 occupants, is that right?
That's correct.
Okay, and I said other 2, but there were just 2 other passengers in that vehicle, is that right?
I believe so, yes.
Okay, and they had indicated to you that they had been drinking, is that right?
Yes, a couple hours ago.
Okay. And so the fact that they had told you that they had been drinking, did that confirm the suspicions that you had or explain why you detected an odor of alcohol there standing at the side of the car?
You re-asked that question. What was
Yeah.
that?
The fact that the passengers admitted to you that they drink alcohol,
Yes.
explain why you smelled alcohol as you stood there at the door side.
It was part of the explanation, yes.
Okay, all right. All right, so I will. I'll continue playing here. But before I continue to press play, you had previously testified that this is a fair and accurate representation of what happened the night of this stop. Is that right?
Yes.
And you had testified that you had observed glassy or it was wet,
Water.
watery, glassy bloodshot eyes. Is that right?
Yes.
Okay. And so that claim of that observation went into your suspicion of ODI. Is that right?
Yes.
Okay. But you previously testified that this is a fair and accurate representation of what you saw.
That's correct.
Okay. All right. Let me continue to press play. Now, okay.
Yeah. The reason why I'm on here today is because you drove over the white line here.
Okay. When you stood there at that side of the car, those are the eyes that appear to be glassy and bloodshot to you?
I would, after watching the video again, I would put bloodshot, but they were watery.
Okay. All right. I'll continue pressing play. Just for the record, I just now stopped at 1:32 and 21 seconds.
Here, you're strapped,
Okay,
okay?
okay.
All right, where you come from?
We went to
Okay, let me stop that there. During that phase 2 of the investigation, one of the things that you're going to look for or be observant about is the suspect's speech. Is that right?
That, yes.
Okay. And I believe, well, did you characterize the speech here of the defendant driver as being consistent with somebody who's under the influence?
I put normal speech because not everybody that's under the influence of the per se limit has their speech.
Okay, so you found her speech to be normal?
Yes.
Okay. All right. Now, going back to the eyes, I'm going to ask you about this. Okay. You indicated that you observed water eyes, is that right?
After rewatching the video, but I know my statement says bloodshot, yes.
Okay. Could you explain why you said bloodshot in your statement, but your testimony here differs?
I didn't watch the video thoroughly at the time, or,
You prepared a report following your OVI investigation and arrest, was that right?
that's true.
In that report you prepared just immediately followed this incident, is that right?
Not immediately.
Okay. I'm assuming it was done within that business day.
It was within that week.
Okay. So you would agree with me then that we do not have bloodshot eyes?
Not bloodshot.
Okay. All right. Now, you had asked whether this driver, the defendant, had consumed any alcohol, and she admitted to you that she had. Is that right?
That's correct.
And she told you in 2 drinks.
That's correct.
Okay. I'll go ahead and press play, so I think I'm jumping a little bit ahead of what was said, but also like to think.
Wow.
The loud, or not even, okay. How much you had to drink tonight?
I have 2 drinks.
Okay, 'cause I can smell it coming out of the car here. Hey, you want to step out of the vehicle for me? Here's the driver's license for me.
Now, I just stopped it now at 1:32 with 40 seconds, and you have asked the driver to get out of the car, is that right?
Yes.
And for what reason did you ask her?
The odor of alcohol, driving, the time of morning, and the watery eyes,
Okay,
and coming from a bar.
okay. And so I understand those are the things that you observed, and maybe my question was confusing, but what was your purpose for asking her to get out?
To separate her from the vehicle to see if it was the odor of alcohol emitting from her, or was it just coming from the vehicle?
Okay, understand. And at this point, were you going to put her or ask her to perform food sobriety tests?
At this point,
Yes.
yes.
Okay. So in your mind, you knew at this point you were putting her through field sobriety tests?
Yes.
And for the record, it's 1:32:40, and I'll go ahead and press play. Okay?
Has anyone been drinking the car today? All right, come on, fill it out for me. You want to walk back to my car here? Other side, not this side right there, okay. Thanks, Bailey?
Yes.
Okay.
And then I have, when I change my address.
Oh, okay. Okay, you stand right there for me real quick. Can you stand right there for me?
Yes.
All right. You want glasses or contacts or anything?
Contacts.
All right, I'm going to stop it right there at 1:33 and 42 seconds. You now have the driver next to your cruiser. You've turned off your strobe lights, I believe, and you've asked whether she wears contacts. What is it you're about to do next?
The start of HDM.
Which is the field sobriety test, right?
Yes.
Okay. So the original purpose for the stop was for winter following, right?
Yes.
Okay. And so at this point, you have now diverted the purpose of holding her there from the original intent of the fog line violation, and you're now conducting the field sobriety test, right?
About to.
Okay. All right. So I'm going to stop this here. Now, when we talk about that phase 2, that face-to-face, some of the things you're going to observe is going to be the speech, which we talked about, right?
Yes.
Which you found to be normal. The other thing is going to be the eyes, which we cleared that up. You found those to be watery, right? Yep. Yes?
Yes.
At 1:30 in the morning,
Yeah.
right?
Yes.
Okay. Now, we're also going to be observant of divided attention tasks. Is that right?
That's correct.
And you have, and when I speak of divided attention, that might be asking questions along with physical tasks, such as get your driver's license. Is that right?
That's correct.
And you asked Ms. Key for her driver's license. Is that right?
Yes.
She was able to find that and give that to you, right?
That's correct.
And in your course of employment and the hundreds of OVI investigations you've had, you've witnessed intoxicated individuals fumble to get that driver's license. Is that right?
That's correct.
But you did not observe that with Ms. Key.
I can.
In fact, she was able to answer your questions while she was retrieving that license. Is that right?
Correct.
Okay. And that would be the divided attention tasks that you're looking for to determine whether somebody's under the influence.
Correct.
Okay. And I didn't see in your report, nor in your testimony here, that you had observed any difficulty with that divided attention task.
That's correct.
Okay. All right. Now, the other thing that you are going to be observant about is the way in which a suspect exits their vehicle. Is that right?
Yes.
And when I say exit the vehicle, and I'm going to demonstrate, somebody as they get out may fumble. Is that right? With their feet or the doors?
Yes, or brace herself, getting out of the car, or anything of that sort.
Okay. And so I've got this part here as somebody might get out of the car, they might even hold on to the car for balance. Is that right? Or they might lean up against the car to maintain balance, right?
Correct.
And I said fumble, and I think I've already asked this, but that triggered the thought that I had. Ms. Bailey wasn't fumbling for her license when you asked for it, is that right?
Not that I saw.
And had she done so, that would have been a clue of impairment for you.
That'd been another indicator, yes.
Okay, all right. So, and I know that this has been a few months and you weren't able to review the video. So I'm going to go over what we would have seen, or what you would have seen on the night that you got out of the car, okay?
Okay.
So what I'm going to do is we have your dash cam. I believe I'm going to play that. And we have just started it. I'm going to kind of bump this ahead. Just follow. So I'll stop it here. This is, would this be your dash cam?
That is, yes,
Okay. And the time is 1:31:52 seconds, is that right?
that's correct.
Okay. I'm going to jump it up for 30 seconds. I'm just getting to the point where Ms. Key gets out, okay? So I just moved it up 30 seconds, and it appears that you're still standing there at the side of that vehicle, is that right?
That's correct.
Oh, I'm sorry, I thought I pressed play.
Yeah, there's no sound when it, with the dash cam.
Yeah,
Well, there is, but you have to be fairly close to the dash cam.
fairly close. But I'm looking at that timer thing, I don't see the timer moving, so I'm not sure what's happening there. Let me go back and see. I'm just going to X that out and try and restart, okay? So Judge, I think you understood, but just for the record, I had moved it forward, but the player wouldn't play. So
Saw that.
I'll let this roll through for a second, for a couple of minutes, so that doesn't happen here. Do you mind if I ask a question? While they're coming through? Sir, in the course of your duties with an OBI investigation, you'll prepare an impaired driver's report, is that right?
But, yes.
Okay, did you do that in this case?
Yes.
Okay, I'm going to hand you defense exhibit.
Okay.
Okay.
Just make it A.
Okay.
Is that okay? Is that okay?
Oh, did I here? I gave you the wrong one. That's trash.
Thank you.
You're welcome.
All right. So we're going to hand you what's been previously marked as Exhibit A.
I mean, you can ask.
Well, I'll ask you about defense exhibit A here in a second, but you just watch the video to your left.
Charles 103182, Charles 103182, Justin.
So So in the video, it's now at 1:32:50. And at this point, you're questioning Ms. Key, is that right?
Yes, I'm making contact.
Okay. And so I'm going to ask you about her behavior or the observations when she got out of the car, okay? So I'll ask you to pay attention to that when it comes up. Let's go ahead and stop here. Now, based on your previous testimony, you had already decided that you were going to put Ms. Key through field sobriety tests when you asked her to get out of the car, right?
Yes.
Okay. Now, we just saw her get out of the car and walk back towards your cruiser. And again, referring to phase 2 of your investigation, you would be observant as to her manner of walking and balance. Is that right?
That's correct.
And you observed no clues of impairment based on your observation of getting her out of the car and walking back to your cruiser.
She did not fumble or stumble when she was getting out of the car, press herself to balance.
Okay.
I didn't think so, no.
All right. And so I think that's all the questions I have about the video. But back to Defense Exhibit A. Do you have that there in front of you?
Yes.
Okay, and that is an impaired driver's report?
Yes.
Right? Okay. And did you fill out that report or prepare that report in regard to this investigation with Ms. Key?
Correct.
Okay. And I think I just have one or two more questions. But again, back to that phase 2, face-to-face contact with the driver. One of the things that you may be looking for, maybe droopy eyes as well, as a sign of intoxication.
Yes.
And we didn't observe that here with Ms. Key, though, did we?
I did not.
Okay. That's all the questions I have. Thank you. We would move to admit Exhibit A.
No redirect.
And no objection to Exhibit A.
No objection either.
It'll be admitted.
Thank you, Judge.
You may sit down to present.
We have no other witnesses, Your Honor.
Any evidence from the defendant?
None.
All right, case will be, is there anything else you want to argue or submit?
I would just like to be heard in summary on my closing.
Go ahead. What state gets to go first if they want.
Okay.
Your Honor, if it please the court, the contention here is that the trooper didn't have a reasonable suspicion. This is not a probable cause at this point. It's reasonable suspicion of impairment, and I believe that starting with the driving, the indication of impaired driving, the indications of the smell of alcohol and the watery eyes, the admission of having been to a bar, having had alcohol, the time of day, I think that justified him getting out of the car, getting her out of the car. Now, that's a separate issue from whether he was justified as going into the field sobriety test. He gets her out of the car to separate her from the other people to make sure that the smell of alcohol is actually coming from her, and he verifies that. So those things, I think, led to enough of a reasonable suspicion to have her submit to the field sobriety test. I think that it's been shown very clearly.
Mr. Nash.
Thank you, Judge. So the Fourth Amendment to the United States Constitution prohibits unreasonable searches and seizures. We're not challenging the reasonableness of the stop of this car. We believe that passes constitutional muster. However, it's expanding that stop beyond the administration of the citation for Mark Lane's violation, where we then delay the stop for an OVI investigation. That's where we're asking the court to apply its attention into whether or not that was reasonable. The trooper walked up to the car and is now in phase 2 of the investigation when he has face-to-face contact with Ms. Key. According to Exhibit A, her speech was fine, and we also observed that in the state's exhibit. Speech is fine, the eyes are fine, they're not droopy. One of the clues of impairment would be droopy eyes. Her eyes were actually wide open. When questioning about the bloodshot eyes that the trooper admitted that he put into his report, actually was not present in the video, and he had admitted to us, not sure why he put that there, but then said that he did observe watery eyes. I still have an issue with whether or not there was watery eyes there. I didn't see those watery eyes with those wide open eyes. The trooper did testify, though, that at the moment he asked her to get out of the car, it was based on the odor of alcohol. But how weighty is that evidence when there's other people in the car who have admitted to drinking, and that would be the source of the odor of alcohol? But the importance of that is she did admit to 2 drinks. He did not ask, when did you have those 2 drinks? The other thing about it is, if the court would look at Exhibit A, defense exhibit, it's not a strong odor of alcohol. We're used to seeing that in reports. Troopers will they'll specify a strong odor of alcohol, overwhelming odor of alcohol. The trooper actually wrote it was noticeable. Noticeable would be consistent with 2 drinks. 2 drinks at an unknown time, which we don't know. And so there were factors that the trooper observed to request field sobriety testing, to prolong that stop. However, there was no consideration given for factors that would cause one to believe that this defendant was not under the influence. And we talked about, again, the manner in which she got out of the car. In fact, the trooper had already decided at the time he was staying at the car, so he was going to get her out for field sobriety testing. But he got her out. She's walking fine, again, speaking fine, only a noticeable odor of alcohol upon her. But none of that went into that calculation as to whether or not it was reasonable to continue or prolong that stop for field sobriety testing. And so for those issues, Your Honor, we would ask that the court consider those facts and weigh whether or not it was reasonable to prolong the stop for that OVI investigation for those field sobriety tests. Thank you.
Anything else?
No, Your Honor.
Okay. I think Ohio courts would find this is reasonable basis to get her out and do additional testing. Time of day is important. Admission of alcohol consumption, admission into a bar, the straddling of the fault line. And he said he was verifying and was going to do the test. I think you could do both. If you got her out and didn't smell alcohol, then maybe he says, okay, well, I'm not going to do the test. But I think our Court of Appeals would find this to be plenty. So I'm going to deny the motion. So how do you wish to proceed, Mr. Nash?
This is unexpected for us.
Well, I can set, if you want time to talk with your client, we can come back for another pretrial.
Your Honor, Ms. Key, with your ruling, has decided that she would enter a plea at this time.
Okay, what plea does she wish to make?
Would a no contest plea be permissible?
We don't object to that, Your Honor.
Okay, with a stipulation,
Yes.
facts sufficient for finding guilty.
Yes.
All right, and do you agree with that then, Ms. Key?
Yes.
All right. Anything that from the state or the defendant on the sentencing?
Your Honor, if it pleases the court, on behalf of the state, Ms. Key's test score is She entered a breath test and it was .101, so it's not egregious. It's not as if she was completely smashed, although her experience in drinking may have something to do with whether she was or not. But under the circumstances, we don't see any reason to ask for anything more than the mandatory minimums.
Right, you wish to,
Yes, Your Honor. You know, the way time goes by, it goes by fast, and I often tell people, you know, at one time, not too long ago, this would have been legal. And now that I think back, yeah, it has been some time since the law changed. But you know, what I think about is, within somebody, there are some people who are smashed, and they know they're extremely intoxicated, and they decide to pick up those keys and drive. There's others that may be a closer call, and maybe this is one where the defendant actually thought, I think I'm okay to drive. And so there wasn't I would say, not a clear, like, thumbing the nose at the law, and I'm going to go ahead and do this. And so I'd like the court to take that into consideration. Ms. Key has taken this case very seriously. This has caused her some stress. Actually, she's never been charged with an OVI before. In fact, she has no prior criminal convictions. She is employed full-time with what we would equate as Department of Job and Family Services in Ohio, although she's employed in Kentucky. It's just had a big impact on her, and sometimes it's the fear of the unknown has a considerable impact on somebody, and that's been her situation. She would like to address the court as well.
Ms. Key, you have a right to make a statement.
I would just like to say sorry for wasting the time and the resources, and thank everybody here, for the trooper and the prosecutor and my attorney, and then yourself, Your Honor. Whatever you sentence me to, I totally trust it. And I'm just really stressed out and nervous, but I trust God that He'll help me get through it. And whatever you sentence me to, like, I'm gonna do it as soon as, if I have to pay fines or fees, I'll pay them today. Like, me and my husband work full time, and I have a daughter, and it's just been really hard because I can't take her to daycare. I can't take her to her doctor's appointments, my doctor appointments. My family doesn't live here, but I just want to show respect for the court and say thank you.
Well, thank you for your statement, and I have some sympathy for your situation, but the thing I would also say about this, I think we're finding out more, the science is that people are impaired even below 0.8, which is the per se level. I think the science would say now that it's much lower than that when it starts having an effect on our ability to operate a motor vehicle. And I mean, you're obviously a young person. This is, I'm sure, the most dangerous thing you do is operate a motor vehicle. You're a fairly small person, so I would say, I don't know, maybe you had the 2 drinks. Depends on the size of the drink and what kind of drink you had. Could you get to 1.0? I guess it's possible. But I think with a test of 1.0, your ability to operate the vehicle is effective. And that's all this is about now. You don't have to be smashed. You know, at one time, I think 30, 40 years ago, that was the feeling. Well, if you weren't smashed, then you weren't really DUI. That's what they call it then. Well, a lot of people have died because of that in accidents. So I think we got to be a little more vigilant about it, and you know, you appear to be a good person, and learn from this experience and go on and have a good life, and just don't have any more of these. You know, if you're going to drink and go out, you know, I said this the other day, and people told me, well, you can't get an Uber in Ashland. Well, you can get one in Huntington, and they're pretty darn cheap. I've used them myself. You know, it's a lot cheaper than getting an OVI is to get an Uber, and they're really pretty convenient. So either plan for it, you know, have somebody that's going to drive you that's not drinking, or call an Uber. That's the solution. Or I've cut way back, you know, and my son really got after me. My son's probably a little bit older than you. Talking about science, the science now is there's no amount of alcohol that's good for you. They used to say, well, a little bit of alcohol is good for your your heart and so forth. And now the new trend is there's no amount of alcohol that's good. That affects your brain and has bad effects, even small amounts of alcohol. So take that into consideration. But I feel like you were impaired. And the video of your driving is the best proof of that. But I'm going to give you the minimums as the state has recommended. I think, which is bad enough. $375 fine is the minimum fine, so I'll impose that. Give you court costs to pay. 6-month license suspension. Now that started the day that you got the incident because you had the test that was over. So that went into effect then. So it'll run from then. Your suspension will be up September 12th this year. If you want to have unlimited driving privileges under Ohio law now, you can do that, but you have to place the blow and go device on your vehicle. If you want limited driving privileges, I'll give you those, and I'll give you privileges without the blow and go to go to work. You're going to have some community service to do, child care. She won't need the court because her review is going to be after her suspension's up. Anything else that you would need driving privileges for?
She just asked about doctor visits for a child.
Okay, I put child care, so, and we'll put medical. Here's the thing. I've never really had too much trouble with people driving with the permits I give them, except in Kentucky, and that's where you live, right? So, because it's going to show up as a suspension on your record if you get pulled over, and then you're going to have this piece of paper from me that says, I allow her to drive for these reasons. Well, then you got to show that you're in compliance with those reasons, and it really hasn't been much of a problem, and even in Kentucky, but a few instances. Might have to explain to somebody over there and convince them that you're in compliance. And the best thing to do is don't get pulled over. And that's actually pretty easy to do. If you use your turn signal, which is a big one for me, use your turn signal, stay within the speed limit, obey all the traffic laws, and you won't get pulled over. And you won't have to explain why you're driving. Okay, then you had a lane violation. I'll impose a $20 fine on that. She'll be on probation for 2 years or until you finish everything. Once you're finished everything you're supposed to do, your probation will end. You have 5 days of community service to do. We have a community service program here at the court that works 6 days a week. What's your work schedule? Is it
5 days a week during the
Monday
day.
through Friday?
Yeah.
You can work on Saturdays. You're going to talk to Mr. Cooper about your probation. And now you also have to go to the driver intervention program, and probably the lady from there is left. Here's the deal on that. I either have to give you jail or I have to make you go to the driver intervention program. You'd rather go to the driver intervention program than spend any time in our jail. So you can go to any program that's approved by the state. We have a fairly new program that just started here in Lawrence County. There's one inside the county, Portsmouth. But you don't have to go to either one of those if you want. Just let you know a little secret. There's one in Chillicothe that's like $200 cheaper than the ones both in Lawrence County and Portsmouth, and it's approved by the state. So if you want to go there, and the big cities probably have multiple ones. So any 3-day program approved by the state you can go to and complete. But you got to do that or go to jail. You don't want to go to jail. No. Your review hearing will be January the 10th. That's a hearing how I determine if somebody's compliant. If you get everything done before then, you don't have to show up. That's because I have plenty of people that don't do what they're ordered to do. So this is judgment day for them. So
What time on the 10th?
9 a.m. on January 10th. It'll be on you're going to get a judgment entry. It'll have that. always check with the court or your probation officer if you have questions about what your requirements are. Okay. Go on, get this finished, have a good life. Don't make any more of these kind of mistakes. You're gonna make mistakes, hopefully it won't be like this.
Thank you.
We all do. Okay.
Judge, just so I've got it, she's got a driver's intervention program, 5 days community service, and the
5 days jail suspended, it's all suspended.
Okay. I just want to make sure I had all those listed, so when that's complete, then she can ask to get off probation.
Yes.
Thank you.
Well, she doesn't even have to ask, it'll just terminate. Once there's no more review hearings, she doesn't have to come back anymore, and the probation will be over.
If those things, I think I missed it, but when those things are complete, she will not need to be here for that review hearing?
Correct.
Thank you. Okay.
Okay, court's adjourned.
Thank you. Do you know what you're going to do? Yeah, let me